A legal bid's underway to get the results of the cannabis referendum thrown out. A group of more than 350 people is asking the High Court to void the vote on the Cannabis and Control Bill, claiming poor and inaccurate information generated confusion among voters. And it claims the Electoral Commission reinforced that misinformation. The bill that would have legalised cannabis was narrowly defeated, with 50.7% of those who voted voting against it, and 48.4% for it. Drug reform advocate Blair Anderson is one of the people taking the case, and he says we heard far too much from the no vote during the campaign.
The failure to correct the misinformation, which Andrew Little had announced at some time prior to the referendum commencing, that they'd have a strong check on misinformation. And we saw ads in the mainstream newspapers of things like dopey dairies, which people will remember. It had cannabis leaves all over it with kids on skateboards in front of it. And of course, there was no such provision within the actual legalisation and control bill to do that. In fact, it was specifically excluded. So there was elements to that. There was the things like gummy bears, the menu for kids, and various others that were publicised in mainstream media and social media and so forth. Notwithstanding the fact that there was also what I call almost stage-managed presentation of people that were, obviously smoking a joint and in hoodies, whereas in actual fact we have a mainstream concurrence with the use of cannabis. Our own health and development study here in Christchurch, 4 out of 5 respondents in that study have used cannabis in their life, and obviously most of them have come to no harm. So
who should have been, Blair, sorry to interrupt, but who should have been responsible for policing that material as you would have liked it to have been?
Well, there was an expert committee that was assembled, and part of its function was certainly to correct any misinformation. But it went beyond that. I mean, even to the extent that we heard that the Medical Association didn't approve of the bill, and then at the end of the period, just close after, bulk of people had voted, had come out and said quite the converse, and that opportunity to explore these things was not taken by mainstream media for the greater part. We never saw the advocacy anywhere in the electoral process, for instance, of the Electoral Legalised Cannabis Party that had participated 9 MMP elections, and no one was consulted as to what they thought the referendum should look like. And things like R18 versus R20, for example, we disengaged the very at-risk group we were trying to protect.
So, where is the problem with that? Because a lot of people would have been engaging in discussion, expressing their own personally held opinions.
Lisa, that's why we've asked a judge to look at it. You see, I could bandy opinion after opinion, and it remains opinion. Now, the first thing, of course, is are we correct in our assumption that referring to end of life in capitals and cannabis in lowercase is a pejorative way to conduct a referendum? If that holds true, then it might be that the judge, I can't predict and it would be wrong of me to suggest it, to predict what the judge can do. But he is empowered under the Act to basically void the referendum. And the question then becomes, do we have another referendum? There is provision within the Act to have another within 6 months of his findings. But I think the right thing to do would be for them just to send it to the Select Committee, and then we can thrash out the concerns like I have about the R18 versus R20, for example. I wanted the opportunity to explore that. I'm a founding director of Educators for Sensible Drug Policy. We've had our play in this in influencing the outcomes in Canada. We didn't need overseas experts here. Nobody reflected the true culture of cannabis in this country, whether we look at 6 Foot Sativa or Catch a Fire or the herbs or numerous other contributions that cannabis has made positively to our communities. Because if we don't understand this...
But Blair, was that just bad campaigning?
No, not at all. We didn't call it cannabis. That was the Electoral Commission that called it that. That's what's wrong here. It's not what we think. It's what does the judge think. If the judge thinks this was inherently wrong and it influenced the outcome, he's probably on a bound to say the referendum is null and void. We're starting to look damn silly. That's not the result of the referendum we're disputing. We're disputing the conduct of that referendum, and I make that very clear.
But the end result is that you desire it to be void, the outcome of the referendum.
Look, it's quite possible that the High Court judge may look at this and go, no. The Electoral Commission could, get a smack over the hand for being naughty, but the results stand. That's the prerogative of the judge. He'll hear the evidence. What's really cute is he can call in the people that were responsible for some of the misinformation and ask them to validate and justify it. He can call in who he likes, he or she. I'm not assuming anything. I just happen to know who it is, but any judge in this situation would be able to call it. It's a very unique setting, this. The High Court has never had to do anything like this in its entire history.
Ideally, Blair, would you be wanting it to be, the result of the referendum to be thrown out, and ideally, would you like the government to push ahead with some change in legislation, not put it back to the people?
Look, it's been put to the people, and 48.4 said yes. I was disappointed to hear Andrew Little say on your own show prior to the specials being counted that the people had spoken and there would be no change, and he thought that there wasn't enough room in the specials there. But if you looked at the specials, it only fell short by a few votes when all said and done.
But 50.7 said no, and that's the majority. So do you want it put back to the people, or if you manage to get the result chucked out, what is the best case scenario?
Best case scenario for the government, because I don't think another referendum in this context would likely to please anybody. I think the right thing would be to say there's a very large sentiment of yes, an extraordinary number.
But there is a larger sentiment of no based on the results.
Based on the results. Wait till the High Court judge says those results are invalid, Lisa.
But as it currently stands, and that's all we've got to deal with at the moment,
no, it's not.
These
We've
are
got
the
a
numbers.
High Court review of the case. It doesn't die with the referendum. The Referendum Act makes provision for this check and balance to occur. That's what we're actioning.
Do understand, Blair, but without that decision yet, what we currently are looking at is a majority saying no. So you don't think it should be up to the people to decide? It
is up to the people. The election itself was a statement by the people. Pretty much Labor and Greens capitalised on the cannabis vote to get in, notwithstanding the fact that there's probably people out there who'd say, no, they didn't.
So that's sufficient mandate.
I've been doing this a long time, Lisa, and I can tell you every damn election we've had, the cannabis vote has had a play around the 5% mark. Now it's having a play around the 50% mark. It's time we all grew up and realised, let's put this to the people. We elected them. They're called MPs. They go on a select committee. The select committee hears evidence, not the trollop that was put out by the likes of, say, Nope to Dope. That's where it stands, and that's putting it to the people because the people elected those people to make a decision.
And that's Blair Anderson there. The Electoral Commission has confirmed it has until Friday to respond to the High Court, but it declined to comment any further.